All right, this is case number 26-190 SM. We're here for an arraignment. Mr. Galvanic, did you read and sign this advice of rights form?
Yes.
Did you understand those rights?
Yes.
The contact information on the back of that, is that accurate?
Yes.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes.
I have a complaint that alleges that on or about January 16th, 2026 in the city of Cadillac, Wexford County, it is alleged in count number 1 that you committed an act of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense. So you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I plan to represent myself.
All right. So before you can do that, I have to be convinced that your waiver of an attorney is knowing and voluntary. All right, so I've got a form here I'm gonna read to you. But before we do that, how many years of education do you have?
12.
You graduated high school?
Yes.
All right, this is, I am the defendant in this case. The judge has explained to me, and I understand that I have been accused of a crime and I have read or have read to me the charges against me and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I have the right to be represented by a lawyer at all stages of this process, and the court will appoint one for me at public expense if I cannot afford one. That I have the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. But the risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection procedure or how to preserve my appeal rights. That because of these things, it can be unwise for me to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. I have 12 years of education. I read and understand the English language, and I am mentally sound. Having gone through all that, do you still wish to represent yourself?
Yes, sir.
Bailiff? The bailiff is going to have you sign this form that we just went through.
Okay.
So you do have the right to be represented by an attorney at all phases throughout this. So if at any point throughout this process, you decide that you either want to hire an attorney or that you want the court to appoint one, let us know and we'll make the appointment, the referral for the appointment. All right. So today, you have a couple of options available to you. One would be to plead guilty. If you pled guilty, the 93-day misdemeanor would enter on your record. I don't know, we probably would not be able to be sentenced today because there's the right for Mr. Galvanic to have victim notification. The other is to plead not guilty. If you pled not guilty, we would set the matter for a pretrial. That would give you the opportunity to discuss the case with the prosecutor to see if there's a way to resolve it, short of going to trial or having you enter a guilty plea. Do you understand those two options?
Yes, sir.
You sure?
Fairly certain.
All right. Today, then, how do you plead? Guilty or not guilty?
Not guilty.
All right. The court will enter a not guilty plea. We'll set the matter for a pretrial, which is that hearing that will give you the opportunity to discuss the case with the prosecutor.
Yes.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. I show a $500 bond was posted over the weekend. You have no prior history. Ms. Lawrence, in the praxis scores you at a risk level 1, which is low risk. Ms. Lawrence, do you have any comment regarding bond?
I do, Your Honor. Our office was able to speak with the victim very briefly. The victim is the defendant's father. He did say he does not wish for a no contact order. The defendant does live with him. He did say that it seems that the underlying problem is likely the defendant's drinking. Drinking was involved in this. The defendant took a PBT that came back at 0.16. When his father tried to take a bottle of alcohol away from him, the defendant began punching and pushing him. So at this point in time, I'm not going to ask the court for a no contact order, but I would ask for no alcohol provision as well as random testing.
Mr. Galvanic, this is where things get a little tricky because I don't want you to say anything about the case yet. But is there anything you would like me to know regarding bond?
Regarding bond, no.
Okay. If I did impose a no contact order with your father, would you have a place to go?
Yeah, it'd be my grandparents. All my stuff's at my house.
Which is where your dad lives?
Yeah, I haven't seen him since it happened. I do understand my drinking has been.
Hold on, I don't want you to say anything. So where have you been staying with your father since you got out of jail?
No, so the first night I stayed at my friend Mitchell Smith's house. His mom let me stay there. The second night I ended up sleeping in my car at Walmart parking lot. And then the third night I was able to stay at my friend Mitchell's again.
And you're 22?
21.
21?
Yes,
Are you currently employed?
yes.
Where do you work?
Cadillac Walmart.
All right, I will continue the bond as previously set with the following conditions: that you appear as ordered, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any alcohol, and you'll be subject to random testing. I'm ordering no controlled substances, including recreational marijuana, and random testing for that as well. I don't want you switching one substance for another. It's very rare that I do this, but I will not order a no contact in this case. But you are to not act in any threatening, intimidating, or harassing behavior, and not to purchase or possess any firearms or weapons. If you are found to be in violation of your bond conditions, you can be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that? Do you have any questions for me about your bond?
No, sir.
You'll need to go out to the front window where you checked in, get your next court date, and then you'll need to go downstairs to community corrections and get signed up for your testing.
Okay.
All right?
All righty, thank you.
All right, thank you. This is case number 26-99-FY, appearances counsel.
Nate Carnes on behalf of the people.
Robert Hertel for Ms. Emard, who joins me at the table. This is another one where I am filling in for Ms. Viavento, who's on arraignments in Missouri County.
All right. Ms. Emard, you're aware that Ms. Viavento is your appointed attorney in this matter, and she's not available for today's date.
Yes, sir.
Are you all right with Mr. Hartel filling in for her?
Yes, sir.
All right. Counsel, we're here for a probable cause conference. Is there any resolution of this matter?
Yes, Your Honor, it's my understanding that the defendant will enter a guilty plea to an added count of child abuse fourth, and there is a Killebrew agreement for sentencing under HIDA in this matter.
Mr. Carnes, what is the child abuse fourth is a 1 year, right?
It is, Your
What's the financial?
Honor. If you can give me one moment, Your Honor. One year misdemeanor with up to 5 years probation. I'm sorry.
I believe it's 1,000, I believe. It's a guilty plea, you said?
Yes, Your Honor, it is with the height elements.
Mr. Hartel, is that your understanding of the plea agreement?
It is, Your Honor.
Ms. Emard, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
So it's my understanding that you'll be pleading guilty to an added count 2 of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year in jail or probation for up to 5 years. Additionally, I believe there's a $1,000 fine that goes along with that.
Okay.
In exchange for that, the people will be dismissing count number 1 of 3rd degree child abuse. That is a felony punishable by up to 2 years in prison or probation for up to 5 years. Additionally, there is what is called a Killebrew agreement. That's an agreement you have with the prosecutor that says you would be sentenced under what's known as the Holmes Youthful Trainee Act. And if you're successful with that period of probation, the charge would be removed from your public record. If you're not successful with it, however, though, the charge would enter. Do you understand that?
Yes, I do.
Now, do you also understand that that's an agreement you have with the prosecutor, not an agreement you have with me? So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
Yes, sir.
Back on May 19th of last year, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you understand that you have the right to have a jury trial, have witnesses called for your defense at trial, to cross-examine those witnesses called against you, the right to testify or to remain silent, the right not to have that silence used against you, to be presumed innocent unless proven guilty beyond a reasonable doubt? Do you understand though?
Yes, sir.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up that right to have a jury trial and you won't have a trial of any kind?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
No, Your Honor.
But Ms. Emard, to the allegation that on or about May 19th, 2025 in the city of Cadillac in Wexford County, how do you plead to child abuse 4th degree?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on May 19th?
My friend had her dog over and we were uncertain how he was with kids, and I looked away for a few seconds and he got my daughter and I neglected to take her in.
Neglected
In
to
my
what?
mind, I
I'm sorry.
didn't think it was bad enough to take her in.
All right. Did she sustain injury?
Yes, she did.
And what types of injuries did she have?
It was just a small scratch to the face on her left cheek. Or no, yeah, it was the left cheek, and then her cat got her 10 minutes later in the same spot.
Was it so the cat scratched her?
It just got a little pin poke right at the top of the dog bite.
How did it get the pin poke?
I'm not exactly sure. She was downstairs with my mother.
Okay. And do you know what happened with the dog? I mean, how she was injured by the dog?
I looked away for a couple seconds and he must have like jumped up and like got her right on the cheek. I didn't exactly watch it happen. I just,
How old is your daughter?
she was 2 at the time. She's 3 now.
And how familiar were you with the animals?
I knew the puppy since the owner got it. He never showed us like signs of aggression until that day.
How familiar were you with the dog?
Very familiar with the dog.
How old would you say the dog was?
8 months,
Had your child been around the dog before?
like 2 or 3 times prior.
And had there been any issues before?
No,
And was there I think you said, but I can't remember, was there somebody with your daughter when the dog either bit her or did what it did?
it was me and my friend Michael, but she was not paying attention either.
And how far away were you from your daughter when it happened?
Maybe from me to the corner of that table.
Counsel, I can't accept the plea. Ms. Emard, it's nothing you've done wrong. It's just based on that factual basis. I don't find that that you knowingly caused the situation or acted in a way that would have unreasonably caused the situation to happen. So, counsel, do we want to keep this on track for preliminary examination? Do we want to reset it for PCC?
Your Honor, if possible, if we can reset it for PCC next week and approve them the following week, that way I'll be gone next week, so. That February 3rd.
Any objection to that, Mr. Hartel?
No, Ms. Fiovenzo also informed me she'd waive the 21 days, and my client confirmed that would be acceptable as well, just so the people in the court both know that.
Correct me if I'm wrong, but Ms. Fiorento's in a 5-day trial that following week, the 27th.
I'd have to double check that.
All right, we will go ahead and we will reset it for probable cause conference next week. All right, Ms. Emar, just a reminder that your bond conditions continue and you can go out to the front window where you checked in and get your next court date.
All right,
All right,
thank you.
thank you.